call it to order. And Terry, you're first up, talking about the sign code amendment.
Yes. This was removed from the agenda on, don't even remember when it was now, but you guys had questions about this.
7/17.
And so one of the first things that I wanted to bring up, and I know that one of the confusions was, had to do with flags. And really, flags should not be part of this ordinance, because what we're dealing with are the First Amendment regulations that need to be enacted. And I have to say, I got a little carried away. And so we need to remove those. And I'm suggesting that we do that when we bring it back to you, so that we are not regulating something that doesn't have anything to do with the First Amendment issues. So if you go through your red line, my suggestion would be that on page 7, item H, flags would be the only thing that stays on in that sentence as being it is a sign for which no permit is required. We wouldn't make any other distinction. Flags would be allowed. If moving on.
Is that one per parcel, any
No,
size?
just flags.
Just
If-
flags, any
flags.
size?
Any
and
size,
whatever.
any,
Okay.
yes.
And-
Because actually flags, let me just, if elsewhere in the code, flagpoles are eliminated from height requirements. So this would, had we gone through this with respect to height anyway, it would have been counterproductive to what was already in the code.
So, and a flag theoretically could advertise a business? Because the definition of flag does not distinguish between a patriotic flag or a country flag or,
And we cannot distinguish that.
Right.
all right,
Right,
if you
so-
have to read
Yeah.
it, then it's, right.
Yeah, so if can I back
Sure,
up?
please.
So just to back up a little bit, you probably remember this from when this was set up for first reading at a prior council meeting, but what we're trying to do here is implement the 2015 Supreme Court case of Reed versus Gilbert, which essentially says you cannot have content-based regulations, particularly for non-commercial speech. So an American flag, any other flag that says anything that's not commercial, you essentially cannot regulate that. So our suggestion is to make it as content neutral as possible, so a flag's a flag, no matter what it says.
Is that like the ones that are on the poles that say, eat here, flagging by the street?
Sure.
That's defined as a flag?
Yeah, it could say the sky is blue, look up. I mean, it could say whatever they want it to say, so.
What about a feather flag?
I'm sorry?
A feather flag, like I have in front of my building?
Yes. Now, we do make a little bit of a distinction around those. Some of them are called, they're not actually called flags, they're a banner.
Feather banner.
Feather banner. But they are allowed
Okay.
as well.
And Terry, can I just clarify on that, the change
Yes.
you're suggesting? Are you also suggesting removing the size as well?
Yes.
Okay.
I am. Now, that's not to say that we don't have a lot of work to do on the sign code, and that hopefully we will be coming back with, probably within the year, to talk about changes, relatively significant changes to the sign code. And at that time, staff might suggest some revisions to this in terms of height and size and number, taking into account that we still have to, we can't manage content.
So this was just, we have a sign code, this is just a modification to try and solve any constitutional problems that might be out there.
That's exactly right. So the flag issue was beyond that.
Sure.
And so we're going to remove that part.
Okay.
And there are a couple of other items that in here on page 12 that would be removed. And that's the only thing that has to do with flags. Catherine and I were talking right before the meeting started, that the ordinance will actually encompass other portions of the code where signage is described. So there are other parts of it, for instance, yard sale signs have to be part of this as well. I mean, and there is other signage that's talked about in the code. And that will come to you at the next reading. Now, if you have any other questions about either the First Amendment issues or other questions about the code, the sign code, happy to talk about that.
Terry?
Yes.
Well, so right now, what we're proposing is what's added in blue and the strikeouts in red? It's-
That's correct. And
Okay.
also, there would be other ones that have to do with flags that would be redlined out as
Okay.
well.
The blue could also be a strikeout.
It can be.
Yeah,
Oh, yeah.
for some reason, between the shoveling of the document back and forth, some changes are in red, some changes are in blue, but they're all changes, so.
Yeah. All right, so I had two questions, and I can remember one of them at the moment, and that is, on page 8, it looks like it was stricken out, the whole reference to off-site signs. So does that mean we're giving up on that one?
How can you determine if it's off-site if you don't read it?
That's correct.
Got it. Okay,
So they may have to be managed in another way.
got it. Okay.
Sandwich signs
Yeah, you are on it.
that are there every day, but not 28 days a month.
We're not going to be dealing with those unless, not in this part,
Okay. Okay,
unless
Okay.
it has to do with the First Amendment issue.
okay. Good enough.
I-
That's my only question.
We do have issues around signs in the rights of way and where they're located and how they're, but we'll address that later.
Question?
Mark? Yeah.
John gave us these pictures. On the
Yeah.
new sign code, can they display the Ten Commandments on a sign?
They can. They are restricted, however, to size and placement.
Okay, and placement, what kind of restrictions on those?
Well, they're in the new code. I think it's 4 square feet. They have to be back a certain number of feet from the property line. And truthfully, at this point, I couldn't tell you whether this meets that or not. More than likely, it doesn't. Doesn't look like it meets it for sign
How'd you-
size.
It's
How'd you
like a
come up
half
with
sheet of
4?
plywood.
How'd they come up with 4?
And also, I do have a question for you about this. Would these be non-conforming, legal non-conforming? Does anything become legal non-conforming once this goes into effect?
Yeah, so just like the use of any property, signs are covered under the legal non-conforming case law. So if someone had a sign that became either illegal under these changes or any future changes, they would keep that sign until it was either destroyed, or they tore it down, or they ceased to use it, or whatever the rules are regarding non-conforming signs. So simply because an ordinance is passed regarding signs doesn't mean if your sign doesn't still, isn't compliant, it needs to be torn down.
Nobody's gonna take a chainsaw and rip it down for you.
Bad idea. Did he lose his voice?
Just don't do it.
How did you come up with the 4 square feet?
Our legal staff did that.
I know it's 2 times
that's
2, but
There's,
Yeah, that's kind of what we see as what people want to see aesthetically. Just, you can make it whatever size you want.
it's typical.
2 feet by 2 feet is barely even a sign.
I know.
But, Jim,
Do I get 1 or 2? Just
as
1?
many as you want.
Okay. On page 2, abandoned sign. It seems to me like it says abandoned sign means any sign promoting any business. That seems to be conflicting with if you have to read it.
That is true. It is. And it was my suggestion that we leave that in. That does not have to be. we had a discussion about that. There are communities that have left in abandoned signage, even though it is in conflict. So,
Yes, so Terry's right. It is probably technically in conflict with Reed versus Gilbert, but a lot of our clients have left it in and are willing to just take that risk to clean up old signage and, you know, that kind of thing, and have that right and just take that risk. There have been no challenges that we're aware of to an abandoned sign enforcement, so the city can make their choices there. And it can always be removed later on if you don't want to keep it, or you change your minds, or you get challenged on it.
Then I don't understand down a couple of paragraphs, area. I've read that a number of times, but I'm not sure I understand what that means in that paragraph.
the second part, where you're measuring 30 inches apart.
Well, particularly
and
when
the-
it says, when the faces are exposed.
Mhm. This is actually the part that Dennis questioned last time that I had not been able to locate. So this is on page 2, and it's the definition of area. So when there is at some point 30 inches between the faces, they could be perpendicular to each other, or they could be like this. More than likely, they would be like this.
That wouldn't be 30 inches, though.
Well, at some point, the
Okay.
wide spot part could be 30 inches or more. So when it meets that measurement, and it's 30 inches or more, then you have to count both faces as part of your allotment.
But is that what that says?
Uh-huh.
I don't get that.
So,
So monument signs, the signs that are closer to the ground, that sit in front of
Oh.
businesses and sometimes have multiple,
Businesses on,
multiple businesses on them, on both sides. And they're made of stone or concrete block, some sort of facing, and they're often double-sided. So then those would be most likely 30 inches apart. If they were, then each side would be considered a sign and added up towards the total.
Yeah, now, I don't remember the exact number, but it certainly was not anything as big as 30 inches. It was, I'm thinking it was maybe 18 inches, what used to be in Canyon City Code, because, I mean, if you look at the sign that we have, it's double-sided, counts as a sign, and it's conforming. So,
Okay. I'm not sure if this was changed in the interim between the time you had your sign and what it states right now.
yeah,
I
that
don't,
that sign's been up there for probably 5 years.
okay. Not in
Like-
5 years, I don't believe it's changed. But I'm not
Yeah.
sure, Dennis. I'd have to go back and see if there were any changes.
Yeah,
But this is what it is right now.
okay.
The sign at 9th in front of the eye clinic, is that more than 30 inches wide? Or between surfaces?
I don't know.
That's a,
It's
that's
a very,
pretty
it's
broad.
a wide sign, but I don't know how
Right, but between
thick
the
it is.
faces, I would think it's not 30. I'm just going off of,
I don't think it was calculated to, based on that.
I have a
Yeah,
question.
go ahead.
Well, because we've ran into this before, so the definition of sign, I think we keep thinking in terms of a two-dimensional something with a picture or writing on it. But the definition of sign can be almost anything. So it's come up before, like, for example, American Liquor had an eagle. It said American Liquor, and then it had an eagle on top of it.
Yes.
And the eagle was part of the sign. Residential, you know, if it's anything that portrays my interest, it could be the toilet I use for a planter. It could be people put things on their mailboxes that are cutesy, that tell about who they are. I mean, that's wide open, endless. And if you,
Adam, I'm going to need you to talk into the mic, please.
oh, sorry. So I just want some clarification on that because we've ran into that problem before.
so what were you?
We're basically saying any object in someone's yard that
Portrays a message.
portrays a message
Yeah.
or their issue, which could be
Whether
really
it's written-
subjective. Are we limiting that?
Not with this go-around, but that's certainly something
But we are, because
that-
we're defining area and you say what a sign is, which is not always two-dimensional, but then you give a two-dimensional area for.
Yeah, but we're not changing the definition of area with this go-around.
This is already in the code, and
Right.
we're not suggesting to make those changes. Now, that may be incongruous with, which is one of the reasons that we really need to probably go back and revisit this code, because I think it was originally adopted in 1991. And
Right.
at this point, based on messaging, the way messaging is done now, and advertisement, I mean, this is archaic. And-
Yeah.
And we do really need to
There's-
make some huge changes here.
Yeah, there's no doubt, it needs a complete overhaul.
It does.
It almost needs to be chucked in the trash and start over again. I mean, it's that, the changes are probably gonna be that significant, but those aren't Reed versus Gilbert changes, and so those are the ones we're just trying to do right now.
Okay,
Doesn't really answer your question, but,
yeah, all right,
sorry.
thanks.
All right.
Whoa.
Mr. Meisner.
Page 6,
Back up.
item, or 173040, item A, where it says that the sign should not exceed 30% of the total square foot on the wall. Do we have a building at 15th and Main, or the highway that applies to? And then you have to read the sign to determine whether it does or does not exceed the square footage, so I'm a little confused.
Tell me what building you're talking about? Oh,
I'm not picking on, but you have to read the entire message on the building to determine if it exceeds the 30%, so therefore you're reading the sign, which would suggest you're violating it.
No, you're taking it a little too far there. So if it said, you can only have, a commercial sign or a sign advertising a business that was 30% of the wall space, that would be a content-based regulation. But this one's not content-based. It says, no matter what the sign says, it can only take up 30%. So that's a content-neutral regulation. And yes, you have to look at the sign, measure it, and figure that out, but that's okay.
So is Mountain Wookie in violation of this?
But that's back to the statement I was making is, they could say, we just painted our wall, and we could argue, but the painting on the wall is showing your interests by the definition of sign.
I don't know that it ever mentions their business name on it, does it?
It has it on
It says
the,
the best little something in the universe, or
I know, but
whatever.
it never mentions the name of the store.
it has it on the street name
Yeah.
sign, but the whole wall's painted that depicts who they are. It's their brand.
I had to drive
So to
by
speak.
twice to see that, too.
Yeah. That's kind of what I was getting at, is it's very subjective on what is,
How it's measured, how the
Yeah,
sign
how it's
area is
measured.
measured. That's what you're getting at,
Yeah.
right? And you're not wrong.
so if we make this change and it covers us legally, then we need to come back and define better constraints later.
Well, it sounds like you need to define how to measure a sign,
Yeah.
maybe more accurately, more objectively.
Right.
That's an issue, yeah. But the 30%'s in there now,
Yeah.
so,
But I think we've been thinking two-dimensional
sure.
writing signs.
Well,
I mean, you could put a big raft up. I mean, like someone's done, you could hang a raft from your sign. That becomes part of a sign. It's gonna be more than 30% of,
yeah. Well, and then I can't find it in here, but there's this thing about the 30% of the total square footage area of the wall. But then somewhere in here, there's also a thing about if it's recessed in the wall.
Right.
It doesn't count. Except, it actually, and I can't find it, but it says if it's either recessed or flush with the surface, well, hell, if you paint a sign on a wall, that's pretty much the definition of flush with the surface.
that's right.
And so those two are contradictory.
They are.
And then, like I said, I can't find the other part of it, but I know it's in here.
I just read it. It is in there.
Yeah,
We don't deny that there are many problems with the sign code.
okay. Okay.
That is one of them, Dennis.
Okay.
For sure.
Another question?
Yes, sir.
Page 7, item F. Does that just mean any vehicle? Is that intended for business vehicles or vehicles that are parked beside the highway like we have now? What does that
Yes.
mean? Or do we know?
No permit is required to put a sign on a car.
See, then I'll go-
And you can park that car in front of
Now-
your business.
But there's nothing in the definition that
Park it
says the
halfway
vehicle has to
down.
be running and operable.
That's what I'm saying. I
That's
mean,
what I'm saying.
like,
So
for
I can
example-
put an old truck in front of my house and put the Ten Commandments on it, and that's okay, but I can't use a 4x8 sheet of plywood.
Well, don't we have a vehicle parked on the highway that's advertising a business? Pardon?
We do.
Yeah.
Yeah. That's been this-
Okay.
We have more than one.
Any more questions, Jim?
I guess not.
Want you to go home happy.
Whatever.
No. They're all good questions, so if you have any more, I would certainly like to entertain them.
So just one little stupid, silly question, which I'm really good at. The changes that are made in this ordinance right now are done to protect us legally because of the other litigation that has been done?
Yeah, it's to bring you into compliance with the Supreme Court holding in Reaver to go.
Thank you.
Yep.
Okay. All right, I think we're done with that one. You're gonna bring something to us and,
Yes, we will do first reading again,
okay?
the entire ordinance,
Yep.
as soon as we can schedule that. And I'm not sure what date that will be, but
Schedule, is
Is
scheduled
it
on
scheduled?
8/21,
It's scheduled for the next city council meeting.
okay. Thank you.
All right.
unless you tell me to.
Is it
do-
practical to say on that vehicle thing that it has to be a licensed running vehicle?
No,
I'm sorry, I didn't hear your question.
Pardon?
December?
Licensed,
I don't
is it
think
a
so,
licensed
though.
running vehicle to put that in?
Sorry, there's too many conversations going on.
Go ahead, Jim.
That's okay.
Item F
No,
on
cheers.
page 7.
Saying no. I was just saying that on the vehicle thing, does it make sense to say that that has to be a licensed running vehicle?
Yeah, we can put that it must be an
But Dennis-
operable
well,
vehicle in there. That's fine.
I don't know everybody's thoughts on that.
Sure.
I think it has to be. That's what qualifies as an operable vehicle. It has to
Sorry.
be licensed.
Well, I'm gonna just bring this up, and it doesn't affect me, but Will has the entire side of a semi-trailer.
It's not a vehicle.
That's not considered, I don't know, is the trailer part of a tractor trailer a vehicle?
Yeah. If it's.
Carries a VIN.
Yep.
I don't know, I guess that's where you'd have to determine that. And there's a number of those around town that are issues, whether
Yes, they are.
whether it's Tony's or the
Yeah,
mayor's
here.
or whoever it is, it's still the same issue.
It is.
Yeah, I'd have to look at the definition of vehicle, which encompasses a lot of things to double check whether it falls within that or not.
Yeah.
My intent wouldn't be at this point to address the trailer issue. Mine would be just to clarify this vehicle thing in the existing regulation.
I'll make a note of that. We'll do that.
Okay, we're gonna move on to the next item. We'll see this one October, or August 21st.
First meeting in
And-
September.
Pardon?
First meeting in September.
First meeting in September now, okay. And Rex, overnight camping.
Overnight camping in city-owned property. When we first discussed this, we talked about the possibility of bicyclists coming through town, having a place to pitch a tent for the night as they move through, and possibly hikers as well. Within the park, that seemed to cause some problems with, as far as maintenance and other issues it might cause. But in studying that a little bit further, I talked to Catherine about the legalities of limiting those who are able to camp in the city park to a bicyclist or a hiker passing through, and how we would actually, quantify that, and are you a bicycler, or where's your bicycle, and that type of thing. So I asked Catherine to do a little research on that, and she might have some words for that.
Yeah, so there's a couple of constitutional issues, and there's also like just a practical issue, which Rex alluded to. So the constitutional issues, if you were to draft an ordinance that said, you know, this piece of property can be used for camping by bicyclists and hikers, you could, like, on its face, it's not discriminatory. So it doesn't say like only men can camp here or whatever. But as applied, you could end up discriminating against a protected class: race, gender, sexual orientation, national origin. There's quite a few in Colorado of protected classes. The other issue is there is some case law out there that states that homeless people are a protected class, or at least they're starting to gain momentum as a protected class. And so excluding them from being allowed to camp on public property and allowing others to could, as applied, be an issue. The other issue is that there may be some free speech issues. These are pretty remote because this is not a traditional forum. My understanding is it's public property, but it's not really part of the park, and is that correct?
In the area that I suggested was between the pedestrian bridge going to Centennial Park and the old ice plant along the north bank of the river. It is city-owned property, but it's not technically a park.
So public parks have free speech protections to them where you can't really just, eliminate people from exercising their free speech rights within them. Since this is not part of the park, arguably it's a more limited forum, but under the right circumstances you could run into trouble. I think that's highly unlikely. And I think the last issue is practically what Rex has, alluded to, is that I don't know how you figure out if someone's a bicyclist or a hiker. I mean, there's some obvious things. Do you have a bicycle on you? But I'm not sure staff wants to go digging around and, checking cars, and I don't know how you prove you're a hiker. I got hiking shoes, or, I'm sorry, you don't have any hiking shoes, you don't get to camp here. So that's kind of a practical issue, not really a legal one, so.
Huh?
A lot of our homeless are hikers.
Yeah, I
All right.
ride all the time and I hike.
But, carry on, Rex.
And like I say, those are the issues that we're facing, but if council wants to move forward, that's the area that I would suggest, is in that area that's the public or city property, but not within the park. And I would also suggest that that be limited to one night only. They're allowed to camp from 5 p.m. and need to clear out by 8 p.m. or 8 a.m. the following morning. Since we don't have an established park use fee, permit fee, or any other fee for any of our parks, there's no camping fee in the Royal Gorge Park, Red Canyon Park, Temple Canyon Park. I suggested not having a fee. But with this trial, I spoke to Tony right before the meeting, and he thought that a fee was probably appropriate, as this is a trial. And I can see in the future, and I've brought this up in the past many, many years ago, but the amount of park use permits that we issue and the amount of other permits, I mean, the park use permits in themselves are anywhere from $300 to $500 a year that we charge zero for. And we have administrative costs in that, and my time, Kathy's time, and other people's time involved in those. So in the future, I see, hopefully establishing a fee system throughout the entire city with whether it's a shelter or a campsite. So I think we should keep that in mind moving forward, and probably institute a fee if we are to institute this trial program.
Go ahead, Scott.
Okay, so regarding camping fees in general, that Royal Gorge campground is one of the best I've ever stayed at. It's really nice. So how far are we from developing some type of fee? Because we should be charging for up there every night.
I agree with that.
It's a lot to maintain.
We have, I think there's 8 of the 22 planned sites that are actually finished, and we're in the process. We normally have to work on it when we have time during the winter months, and that's when we did the last 8 campgrounds. But I would think, it'd be a year or 2 down the road, and when that project is finished, and additionally, I can see a campground host coming in there, because you know, at current staffing levels, we can't be there every day and watch. And there's a lot of stuff that goes on up there. And there's a lot of people that overstay their 72 hours, and we have to go up there and kick them out. So a campground host, especially in that park, and hopefully, you know, Red Canyon Park and Temple Canyon Park in the future, I think is something we really need to look at and institute a fee program there. I know the BLM for up at the banks, they have a fee. You know, it's a just on the honor system, you put your money in the Iron Ranger and hope for the best.
Right,
But,
and so given that 2 to 3 year, or a year or two off is quite a ways, and it is eating up a lot of manpower to manage all this. I don't know why we don't get a head start on this. Something for us to come back and visit maybe sometime soon, because as he alluded to, there is some problems up there. I was up there twice last week and camped on 2 different occasions, and there were parties going on, and again, it's free, so why not stay and hang out for 2 weeks? So something for us to think about. They're really nice campgrounds, and if we can continue to develop that infrastructure, we might want to set that
I
up.
think the host idea is awesome, because it's something that's not taking manpower out of the city, it's not city payroll. Somebody's getting to stay in their
Right.
RV there, and collect the money for this campground, and, you know, and make sure that things are going on that should.
And I think there's a lot of people interested, because actually I ran into a guy that was camping at the Gorge and got to talking to him, and he said, you know, would you be interested in a campground host?
Yeah, that
Because
makes
my
perfect
wife and I traveled, we'd love to spend the summer here.
Mhm.
And I said we've been thinking about that, so I don't think it would be hard to find it.
Okay.
And I think what we would have to pay those hosts would be minimal.
Would be nominal, right?
A lot of them will work just for their site, someplace to park their RV,
Right.
you know,
Typically, I
for
don't
free.
think they even get paid.
No, they
And
don't.
see,
It's
that's
volunteer.
one
I
issue
didn't
that we
think so.
will need to address up there is, typically the campgrounds that I go to with the campground host, there's electricity, there's more amenities. This is pretty primitive camping at the moment. But power lines run right through there. They're not very far away. So even if we could get, you know, if it remained primitive camping, we could at least get some power, you know, to the campground host, so he can charge his batteries and keep everything going like that, so.
So related to this camping along the river for next season, again, the only thing I would encourage is perhaps a fee at this point, but if, we'll just have to talk about what that looks like.
I think that would eliminate some of the other issues, if it was
Yeah.
like $5 a night, which is, you know, a reason, whatever number.
You know, along the river, they still have to pull a permit of some sort, though.
Right, and
Yeah,
I
I
alluded
saw
to
that.
in this, but.
So there's still going to be, there is going to be some paperwork involved, and it'd be nice to recoup some of that cost.
Right.
But other than that, it makes sense.
Uh,
Anybody can camp one night along the river a year.
I thought we were going to try to address some sanitary issues.
Well, at the moment, our restrooms are locked at 11 o'clock at night, and they're reopened at 5 o'clock in the morning. It wouldn't be any different if the campsite was in Veterans Park or along the river, because the closed amenities are the same distance away. So there is that issue. I mean, in the middle of the night, what are you going to do? So the restrooms are locked, and those issues exist. That,
Again, this is
could become a problem.
primitive camping. And
Absolutely.
primitive camping exists throughout the state. You roll up and you just go to sleep. It happens everywhere, so. Yeah, it's not complicated. To me, this will meet the need of why I originally brought this forward for cyclists.
And in that particular area, there's no, there's shade available. It's right by the river. It can lullaby you to sleep at night. And no utilities or anything like that, irrigation systems or anything to deal with. So it would be a much better location, in my opinion. And I've actually talked to the Chamber of Commerce, and they were willing to issue permits at the tourist cabin at Veterans Park. And another thing I would suggest is that we don't advertise this. If someone rolls through town and inquires about, is there anywhere that I could pitch a tent for the night while I'm traveling through? But I think if we start advertising this, a you know, a night of camping is gonna blow up. But,
Yeah. My suggestion on this would be, seriously, to make this a self-registration campsite, just like all the Colorado State parks, like all the campsites, all the way along the river corridor. It's, you pull out a little envelope, you fill out the information, throw it in the tube, and put your money in there, or put no money in there. But the whole concept of having to arrive before 5 PM, I think that's not a workable concept. I think
it
it's.
probably isn't, you know, my thought on that was, you know, City Hall closes at 5 if they wanted to come here to get a permit. Most of the time, they're gone over there at 5 o'clock, so who's gonna issue the permit?
Right, I
after
think
those
just a
hours?
simple self-registration is what you need. Put it in the tube, it's easy to check, you know. The police are coming through at night, they can open it up.
We're actually gonna retain private security, the same
Yeah.
people, so they can check on it.
Right, they
Just
can,
wake you up and say, hey, where's your $5?
yeah.
How would you know if they had one night or 2 nights, or
So.
if they were a
Well, that's
homeless
the
person?
thing,
I
I don't,
think-
it's,
Or the homeless
if you
people.
did it, I mean, theoretically, you could do it for one night every night.
How about if the homeless did it every night? for
So,
one
Well,
night?
that's what I
with the,
just
with
said.
the one night, if the security firm finds the same person camping there,
Yeah.
I mean, at
Yeah,
that
and
point,
that-
they're in violation of it, whether they paid or didn't pay.
Yeah, that's why I
Catherine?
suggested the one night and one
What do you
night
think?
only.
I think that would work.
Will that work?
Again, one night
night
is gonna satisfy these cross-country cyclists, and that's all I was, that's all I was proposing. It's also gonna, are we gonna allow them to stay in their RVs along the side there?
See, I suggested in my memo here that we don't, we just allow tent camping only, but we might be going back to, you know, some sort of discriminatory issue if we don't allow RVs to camp in this location.
Well, not on the RV side, but on the homeless side, if they don't have tents,
Yeah.
or people who aren't homeless don't have tents. So,
I mean,
you can,
if you're in an RV, why would you camp there? I mean, you can go up to the gorge.
Because,
or you can go
because
up
people do it all the
on
time,
8
or,
Mile.
yeah.
Have you seen some of the RVs
You
running
just-
around out there?
You're looking for a place to drive. I mean, people
Mhm.
sleep in Walmart parking lot, so if it's open to camping, and again,
Why don't we
And then
bring you
there's a-
back something for an upcoming meeting? I mean, clearly it's a trial, so we're gonna run into issues we maybe not have anticipated, but that's why it's a trial.
and that's all I was,
Yeah.
I was just hoping for a trial, so,
Yeah, so we'll put something together with a small fee.
$5.
Yeah.
And another issue we might run into is there's a limited amount of space there. So are we gonna allow just one person per night to camp there, 1, 2, 3, however many? There's probably not room for more than 3 comfortably, maybe 4. But,
Let's see what the
you know,
demand
I
is.
think what you were targeting was, you know, the people coming through town to say, I want to throw a tent up and.
Right, so let's just try that and see what happens.
Are there gonna be like
One night.
designated spots?
No,
Like
that's,
Spot 1, 2, and 3?
no, just
Just whatever.
whatever, yeah.
Yeah,
So
and-
we're shooting for next season?
That, yeah.
Summer of
2018.
of 18.
If it's an
Yeah.
overnight, you know, like Rex is saying, or Scott's saying, if it's an overnight, chances are they're in there, they're gonna grab some sleep, they're gonna pack their stuff, and they're gonna go away in the morning. They're not there for a vacation resort.
Right.
And is this just
that's
simply a
what we're
policy
looking
that we're putting together here?
Yeah.
So it's a simple policy, and we can work, let's get it done so that we can start in the spring. We'll go
Yeah.
spring,
Back to you on September the 4th.
spring to
Yeah,
fall.
well, and just one more comment about the whole tent thing. I've got a collection of tents, but even when I'm camping, I don't always use them, depending on, you know, if it's 80 degrees at night, I'm sleeping outside, I'm not in a tent, just so.
Yeah.
So anyhow, okay. So I think we'll just look forward to seeing
Dennis.
something, yes. Oh, John, you want to come up to the, yeah.
I thought he talked about it.
Yeah.
Hi,
Okay,
John.
yep, oh, sorry, John, we're gonna go step back to the sign
Well,
issue.
maybe I can connect them
Sure.
up here. So if you have your tent and you paint a sign on the side that's less than 30% of the area, does that, are you good then, or what, you know? Just kidding.
What would
Just
you be
kidding.
selling in the tent?
Okay, go ahead, John.
But back to the sign issue, I would, on the definitions and in the signs that, for which no permit is required, you do have the political part in there, and you do limit, it's unlimited signs, but it's 3 square feet per sign. And I would suggest that you not put a square footage on what's prohibited necessarily there. I mean, you know, if it's gonna be for an election and every couple of years, people like to put up big signs sometimes. And so my suggestion would be to not have a limitation on square footage there. And the picture that I gave most of you, at least that you could pass around up there and look at, that guy does put up signs all the time on different issues, and so it's by limiting it to one sign also for no permit, that's also, I think, you know, something you should think real hard about doing. It in a residential area, it doesn't matter if he had 2 or 3 signs. I mean, are there problems right now where that you're aware of? I'm not aware of any where people have multiple signs that look bad, and you know, so if the idea is to protect constitutional speech, putting a limit on the number and the size of signs may not be compatible with our community, how things work here. So that's my comment.
All right, thank you, John. All right, the next item is our Black Hills franchise agreement. Tony?
Should turn this over to Catherine, and I know that plagiarized her, she's suing me. And then Adam has some good comments, but let's start with Catherine. The only section I'd like to talk to you about as you get to it is really the penalty provision for outages. That's been a common concern about in the community by the council, and I'd like to get some direction on that.
So I'll go first. So just to let you know, you have a little breakdown of the status of the ordinance. We're still working on it in our office. Adam and I have some issues to sort through, and then Corey and I will need to sort through it. And then I would like to bring it back to you guys to actually see the full ordinance. It's about 25 to 30 pages, so it's a monster. And it's obviously in process, so that's why you don't have it in front of you tonight, because it's not in good enough draft form for you. So as Tony lays out in his memo, these are just some kind of highlights and bullet points, some things we need direction on, some things it's just letting you know if you have an issue with any of these items. This is the time to speak up and let us know if you have any concerns or things you don't feel like were addressed in your last ordinance, which is obviously long before probably all your times on council. So that's about it. We can go item by item if you'd like, or I don't know what Adam wants to say.
Yeah,
Well,
do you want to
let's-
go through each item, Dennis?
Yeah, I think so, just because I think there's a number of these items that are probably new to the franchise agreement.
Well, actually not. That's part of the issue is some of these things that we're saying need to be in there, they have in their initial draft taken them out. The old agreement was pretty substantial, and they gave us how many pages?
3?
Yeah, so.
Got it.
So, yeah, we can go through it and just kind of, these are the things that we think are significant issues that may or may not be sticking points.
Okay, yeah, when I was reading it, I got the impression like, oh boy, we're asking for all kinds of new stuff. But that's not the case. Okay, so let's go ahead. We'll just start with wherever you want to start, and we'll go item by item
Okay.
briefly.
So the term of your current franchise is 25 years, so we're proposing the same amount of time. It doesn't become effective, obviously, until the electors approve and the PUC approves it, because they're regulated by the PUC. The franchise fee is currently 3% of their gross revenues. Adam did want council to discuss this to make sure we want to move forward with that fee. As you know, that's charged to the consumers. That fee is not charged to the city for the electricity that you receive from Black Hills.
Yeah, I'm not suggesting you change it. I was only wanting to inform you that this is the time to negotiate it if you want to. But this is a pass-through to our consumers, to our citizens.
Right, and this is a general revenue item. General fund.
Franchise fee.
Yes.
Yeah.
probably.
Yeah,
Yeah.
that's where it goes.
Yeah, general fund, yeah.
Yep. What's typical in other cities? 3% is pretty
Well,
common,
in the state of
isn't it?
Washington, they have a typically anywhere from a 16 to 20% tax on utility bills. It's a
Yeah, I don't
huge
think we're
source of
going there.
income for cities. we're not proposing that, but 3% by comparison. 4 to 5% in other states is more common. 3 is the lowest I've ever seen. But again, it's a function of this is paid not by Black Hills, but by their consumer. So
Right.
it's basically a tax. And so do you want to increase that current tax burden on the residents?
All right, let's
And
go.
this, when,
Mark,
I'm thinking not.
you'll stay with 3 or change?
I'm thinking stay with 3.
Jim?
I mean, it's low, but
I'm not in favor of increasing it.
Preston?
What do we gain a year from the franchise fee? Can you give us an approximate idea? Is it 100,000? Is it 10,000? Is it?
There's a couple hundred thousand
Couple
by
hundred thousand.
recollection. Unfortunately, I could have gotten that from
That's
Harry,
fine.
but.
That'll get you.
I'll send it out tomorrow too.
Yeah, I'd keep it the same.
Yeah.
Kathy, change it, keep it?
Actually, I
Keep
can
it.
Scott?
I'm
raise
interested.
it 4%?
Okay, I'd say just leave it.
Yeah, we just wanted to let you know that this is the time
Okay.
to discuss that. And you can think about it more as we bring it forward.
Yeah,
That's
you
a
can-
quick change in the ordinance if,
Oh, yeah,
As
that's
we
an
move
easy
forward.
change. And the other associated issue is the current franchise, if you do want to increase that franchise fee, requires a public hearing. Did you want to keep that process? So that the citizens could come and talk to you about whether or not you should be raising that franchise fee?
Yes.
Wait,
They
it's,
said leave it, though.
if we
No, like-
change the franchise fee or
Yeah,
if
like
we have
10
it at all?
Well, no, you'd have it, so it'd be, let's say it's at 3%. You approve that ordinance, it goes to the voters, they approve that. So 15 years from now, you're about halfway into your franchise, and you want to raise it to 4. What kind of process do you want to have in place to do that? Currently, the franchise requires a public hearing to raise that fee.
Ah, okay.
So I'm asking, do you want to keep that process?
Don't make it an election.
things are gonna change as we go forward. I mean, and, it's a 25-year agreement, so you never know what's gonna happen in 10 years or 15 years.
Okay, we'll keep the public hearing process.
Yeah.
And so given the fact that we have very little opportunity to raise
Things
sales
the
tax,
same.
you guys want to leave it the same? This is the one chance that we have to actually negotiate and get a little
It's,
bit more tax.
well, you know what, my answer is gonna depend on what the revenue generated
yeah, I
is.
think that's going to be important information to get to you. We'll get you that, because at the very least, we want to pay our light bill. And,
You're right, well, that's what I'm thinking, it should be enough to pay the streetlights.
yeah,
And
so we'll get that information for you.
Okay,
And also, though, the bills are gonna go up. And Black Hills is gonna get an increase, so we get an increase too.
Maybe. It
What?
hasn't gone through the PUC yet.
It
I've
will.
got 2 letters of protest through
it's,
it.
okay, let's move on to the next one, 4.
So the franchise fee is usually structured to be in lieu of other payments. So, your permitting fees for encroachments in the right-of-way and those kinds of things. So Adam's actually suggesting as an initial negotiation point that we do not exempt the permit fees, the inspection fees, so that's the inspections done after work is performed in the right-of-way, and the street damage restoration fees. So they would still have to pay those.
Which would, so back to that might be another reason to change the fee. Currently, the only utility that's exempt from those fees is Atmos Energy. And practically for us that administer those things, it's been a real pain. And it's been problematic. So we argued against that last time with the renewal for Atmos. I would make the same recommendation again when Atmos comes forward, especially with the new street damage restoration fees. So not knowing what those damages are, to leave the fee the same and exempt those things where they haven't been exempted for Black Hills in the past, we'd be losing, on the losing side.
Okay,
Can you pick, could we say stay with an inspection fee and permit fee and not do the street restoration fee, or?
Right, so that's what we
Yeah.
currently do with Atmos. So Atmos, the way we structured our street damage fee ordinance, Atmos is not exempt. Even though we call it a fee, they're not, because of the way we structured it, where since they're affecting the street and they have the opportunity, they can either pay the fee or repair the road full width. It's cheaper to pay the fee, but we gave them the opportunity to not pay the fee if they don't want to. So the way it's currently structured, We do charge Atmos the street damage fee, but they don't get charged permit fees and inspection fees.
Okay.
So that's a middle ground if you wanted to go that route.
I would like to see them the same, whatever that is.
Yeah.
Yeah, that's a big point that I was trying to make, was treating this person different to this person has been not fun. So, yeah, if you don't want to do something, I would suggest do the same thing we got with Atmos.
Okay, so the suggestion is to treat Atmos and Black Hills the same. If you disagree with that approach, let me know, otherwise we're moving on. Moving on. Okay.
Just as a point of information, I went upstairs, each % of the franchise fee generates $185,000. So 3% in total generates $555,000. And then we do charge sales tax on top of that, so combined, it's about $1.1 million. So it's a significant source.
Yeah.
And I think the light bill's right over 200, 250, I think is the light bill.
Okay, well, that's certainly covered, but, we can talk about some more, but I think I'd support actually increasing it to 4.
So-
All right,
Go ahead.
I'm just gonna turn it over to you for number 5.
So the franchise as currently and as is going to be drafted allows the city to audit the franchise fee, go through the records, request reports. That's pretty standard. The penalty for interruption of service, so this is what Tony referred to earlier. So I just drafted some kind of general language to guide the conversation that's in Tony's memo there. So I wasn't here for the discussion you had regarding that penalty, so I don't know if that's really what you're looking for, but I'm looking for some direction as to what your thoughts are on that penalty for power going out, and what triggers that penalty, and what it should be.
Go ahead, Jim, I got some thoughts on this too, but.
Well, I was one of the people that maybe initiated that. My frustration is in our electronic society, not only commercially but personally, any kind of a power inconsistency or outages is a major event. There seems to be, in my interpretation, a lack of disregard or concern with Black Hills Energy in terms of why it happened. Is it going to happen again? You know, the power goes out, it's like, well, the power's out, and it'll come back up when it comes back up. If City Market has to shut down for a day,
Yeah.
okay, well, there's no power. There seems to be no regard or no disregard or concern for power outages. And in this day and age, I just think that's inappropriate.
We had 3 in 1 week that were in excess of 3.5 hours. And there was no reason. You call and you get a recording and it goes to whatever.
Would it matter what the reason is? That'd be one thing.
Yes, I think,
Well, if there was, you know, a severe car wreck or, you know, something, and it knocked down the transformer in the middle of the highway, it
Right.
would be more
Well, yeah,
understandable
yeah.
than that there is just nothing and you get no excuse.
Well, I'm just gonna say, I'm pretty sure Black Hills doesn't go and turn the power off. And so there's always a reason, and it's probably a good reason. The question is if you wanna penalize them for something that's beyond their control.
well, I don't know that they're necessarily beyond their control, because
Yeah.
if we have equipment failure that hasn't been properly maintained
Yep.
or hasn't been replaced within the recommended replacement cycles in terms of transformers that don't get replaced, then I think that is their fault.
I know in Florida, they have a lot of these penalty provisions, and the only exception is an act of God, which is typically things like tornadoes, hurricanes, and they're well-defined. But everything else is subject to a penalty.
I mean, I'm going to say that 99% of the time, it's some kind of an equipment failure. And if it's an equipment failure, there's a high probability that it could have been prevented through a preventive maintenance program.
Catherine, are there other municipalities that we can refer to?
I've never seen a penalty provision in a Colorado franchise agreement, but we can certainly poke around in other states.
I don't want to set a precedent necessarily in Canyon City regarding that, so.
I do.
You do, well.
Well, this is a contract that you're negotiating essentially. So,
25
you know,
years.
you're not passing laws necessarily. I mean, I know it's an ordinance, but, you know, I think you can set that precedent. I mean, Black Hills can say no,
Right.
you know, so it all depends on what you guys want to do.
Jim does have a valid point. This is a 25-year deal. all our lives have been changed by electronics and digital technology. Can you imagine what the next 25 years is like? Any disruption will be
Well,
more catastrophic.
When
I
the-
mean, we
you-
went
you
through a
have-
period of a month ago at about 7:10, for 3 consecutive days, we had
Yes.
power.
Yep.
That's 7:10.
So-
You can't tell me that's coincidental.
So Jim, how many times a month? One time a month in excess?
Yeah, one time a month.
Well,
would
if it
be-
damages my hard drive
Yeah, or your
or
refrigerator
your
with all the
hard drive,
digital,
we have a different scenario, and that's very, very possible.
One time a quarter.
and they have no, they don't have
So,
no record, they don't have.
so what are you
any-
thinking, Jim?
Well, and we don't have to do it by times, we can do it by, if it's over an hour in a month long, like if you hit that second hour, it doesn't matter if it's the same day or not. I mean, we can
That's
get very
good.
creative about how we
I
want
think
to.
as we go along, it would be nice to try to get some qualifiers. That my concern, again, isn't the act of God
Yeah.
or an accident. Those things happen.
They do.
But I'm talking about a company that is not proactively trying to make for sure that they don't have failures. And I just believe that they are not doing that.
Why don't we do some research and bring you back some different options, rather than trying to determine.
In this little contract or franchise agreement, what happens if there's an impasse? Do they unplug Canyon City?
No, they can't.
Okay, I mean, it's just like, okay, I mean, what negotiating ground do they have and what negotiating ground do we have?
Well,
City can purchase the franchise. That's
yeah,
the only.
yeah, I
really-
mean, you can purchase the franchise.
Yeah, yeah.
Boulder's going through that
Some
right
cities
now.
have done that.
We can
We're
get
not
in the power
suggesting
business.
that.
We
I
can
have
get
a
in the power
client-
business ourselves.
Yeah, I have a client who has their own electrical system, and they can't wait to get rid of it.
But I've been in
Oh, I
cities
can
with
understand
electrical
that.
systems that are huge cash cows, but it depends, again, the quality of the operations and the customer base. It's a business. And if you run it well, you make a lot of money. If you don't run it well, it's a burden.
I don't see Colorado Springs trying to get rid of theirs.
Most
No.
cities, it's very lucrative. It has a significant benefit to the general fund in lowering the tax base.
And you've got control over it. I
Yeah.
mean, it's
But it's
crazy.
a totally different enterprise, it's very complex, it's sophisticated. We certainly wouldn't recommend it, but it is an option. Most cities who have electric utilities have had them for sometimes 100 years. I mean, they were the original utility, that's why they're in the business.
Much
Very
more-
few like Boulder have acquired
A
them.
much larger population
you know,
also to spread the.
At this stage of their
cost.
existence.
City used to own the
So we'll move
gas.
on and they'll come back.
We'll bring you some examples.
Okay. Number 7.
Yeah, that one's a no-brainer. If they damage something, they gotta fix it.
Okay. Number 8.
So this one come up, I just thought of this one, I have seen this in other places where there's some, and there might be some constraints on it, but currently, if we have a request for a streetlight, either you as a council decide to pay for it, or we've had private individuals choose to pay for a public light. But Black Hills doesn't install it at their cost for a streetlight. So just throwing it out there, if you wanna see if they'll pay for new streetlights. Obviously not unlimited, but maybe with some constraints. We have a city policy on a minimum standard of where the lights should be. We can throw that at them and see if they're okay with that. I don't know, it's just putting it out there.
In the past, have they ever paid for streetlights?
No.
Yeah, I don't think they're keen on that. How about if we ask them to comp the streetlight bill?
Yeah.
Well, it's a public service.
Can ask.
Yeah, fire
Yeah,
away.
Doesn't hurt to ask. They can
Yeah.
always red line it off.
So again, maybe, that might be something you wanna sleep on too.
Yep. All right.
Number 9, enforcement of their pole sharing agreements. So, and Black Hills has admitted this as an issue. So the problem is, Black Hills, for a fee, allows other utilities to use their poles. Then we have a project and we need a pole moved. And Black Hills is very responsive. They're very quick to go out and move their stuff that's on the pole. And the process is they're at the top. So they move their stuff, they chop off the top of the pole down to the next utility. That utility comes in, he moves their stuff, they chop off the top of the pole to the next utility. So whoever's last on the pole is supposed to remove the pole. The problem is usually the bottom pole is communications. We don't have any real enforcement mechanisms. We don't have franchises with communications. So we don't have any teeth to get the communications people to move. So Black Hills gets their stuff done, but they have a pole sharing agreement with the communications people that says, when we need our pole moved, you'll move too, and you'll do it in such and such time. And either their agreements have been lacking or they haven't been enforcing their own agreements. And so we want to put a little heavier language in our franchise that says, when other people are on your stuff and you're moving because we asked you to move, then it is on you and imperative that you
Your responsibility.
make your tenants move as well in a reasonable amount of time.
Right.
But if it's their pole and they're charging people for it, why can't they be responsible for the finalizing of moving their pole?
Because they won't touch the other utility.
Right.
By their agreements. And the pole can't be moved until that last utility's gone.
I understand
But if
that.
CenturyLink says, yeah, we'll get to it in 6 months, maybe, that's what happens. And so we have the real instances in town you can drive by right now, there's 2 poles sitting right next to each other, and CenturyLink is still hanging on the old pole. So we have a pole farm down the street. It's ugly.
I'm for it.
And they do.
Stronger
Yes.
language.
Okay.
Let's do it.
Okay, number 10, information sharing.
Yeah, so we have a separate agreement where we are sharing information, basically GIS data, between us and Black Hills. The main purpose behind it was years ago, we asked them to give us a database that coincides location of the streetlights with the billing. Because our billing for streetlights is like a mess. We'll have like one page that'll have 20 lights on it with no identification of where they're at. And then we'll get another page that has just one light on it with an intersection name. And then it's a stack of papers invoicing. They have done a better job. They have since went and numbered all their light poles and put those identifier numbers and attached those to their database. They're still having a hard time matching up their GPS locations to our database. But that was the intent of that data sharing agreement, was so that we can match up and make sure we're not paying for private streetlights, or, and vice versa, that kind of stuff. So those had different terms. So Catherine's suggestion was we just roll that data sharing into this agreement, so we only have one agreement with Black Hills.
Yeah, the information sharing agreement's like 5 years, so
Yeah.
we'd like that to continue and not have to revisit that issue.
Yeah.
I don't see that changing.
I don't think anybody has a problem with that. Moving on to the next one.
Speaking of the 25-year term, technology's changing all the time, and actually what we have installed in the city is way behind. The only LED lights that we have installed are the ones we paid to install on Main Street, because those are the ones that are metered. So when a street light gets broken, or we ask to install we pay to install a street light, they're putting in standard equipment. So there's nothing in our agreement that says, hey, if there's better technology that's gonna save us money, they're not installing it. And we don't have anything really to make them install it. If a developer came in for a subdivision, the developer has the option, because they're buying the initial lights, they can pay to upgrade those. But Black Hills isn't on the hook to use anything other than what they decide is standard equipment. So it seems like, and I don't know what language we should have in there quite yet, but it seems like we should have something in there where that when they upgrade or replace stuff, it should be the new stuff.
The most energy efficient.
Right.
Yeah.
Probably the best language is from the air pollution industry. You put in the phrase "best available technology."
Yes.
Yeah, and efficient, right? I mean, so we need something in there, I think.
You know, whether it's 5 years
It
from now.
would be
or 20
expensive. I mean,
years
some
from
places are looking at, and they've worked with Black Hills. Pueblo did a huge section of town where they did a huge LED conversion.
Right.
And got some rebates back and that sort of stuff. I'm not suggesting that we make them go and flip everything to LED tomorrow, but if new stuff gets put in and replaced, it should be the new stuff.
Yeah, well, I think putting it in there is good. It's gonna be a negotiating item, just
Sure.
probably everything in here, so.
Yeah.
Dennis,
Yeah,
on the streetlights, you mentioned that how do we pay for streetlights monthly? Are they metered, or
No.
we just paying a
well,
base rate?
It depends. So some are metered and some are not. All the ones on Main Street are metered because they're special lights that Black Hills wasn't going to maintain. There are Acorn
Right.
historical lights. So we actually own those poles. If they're metered, we own the pole and the light. If they're not metered, if they're flat rate, then they own the pole and the light. It's their facility. We just pay the bill to light it. That's the majority of them. But there are a few around that are metered. So it's, yeah, like I said, the billing's kind of
Okay.
goofy.
Number 12.
Number 12, they took this out of their new draft. It's in our existing draft. Basically, not streetlights, but let's say we want to put up a new stop sign flasher, or a school flasher, or a splash pad, or new pump house, or something like that. The current agreement, they provide that new drop and service to us. We have to do all the electrical work downstream of the meter, but they provide the service to us for nothing. They took that out. I think that needs to stay in. That's a big benefit to us.
Okay.
Yeah, to the tune of thousands and thousands and
Yeah.
thousands of dollars.
Yeah.
13.
13, undergrounding, they took everything out of the agreement for undergrounding, but.
Which isn't that surprising, but.
Yeah, undergrounding is expensive. Our current rules for development are if it's new, it's underground. We don't, again, back to the pole farm, we don't want the poles, we don't want the aerial, trying to clean up the town, what it looks like and that sort of stuff. So, new stuff, I think again, new stuff, unless it's completely unreasonable, if it's an expansion, new subdivision, some of that, it should be underground. Those have been our rules for a long time now. And then another concept is they put aside a certain portion of the money they collect. Is that right, Catherine?
It's another 1% on top of
It's another 1% on top of that they put into a fund for future undergrounding of stuff that's, let's say we decide we're going to improve the river corridor and we have all these wires overhead, like on the Black Hills plant site, and we've now saved up $2 million in that fund. We can say, okay, we want you to underground everything over at the old plant site. And then they use that money to do that.
The undergrounding also is directly related to disruption of service. The more you get underground, less ice problems, less wind
Correct.
problems.
Right.
It makes a material difference.
Right.
And disruption.
Which makes smart,
Squirrels don't
less
electrocute
maintenance for
themselves
them
and
in the
such.
long run.
I mean, reality, if it's aerial, the only time it should be aerial is if they're replacing what's aerial now, or they're doing some major transmission somewhere that's $1 million a mile type stuff like
Okay.
they did out
I don't
east.
think there's any disagreement on
No.
leaving that in there. Number 14.
Okay, so 14, this exists in our current franchise, plus we want to beef it up a little, just clarify it a little more. But essentially, if they're in our right-of-way and we need them to move, they ought to move at their cost.
For a public project.
For a public project, right, or purpose. One thing that's been a sticking point in the past is we get a developer that comes in and we ask the developer to do something, like, let's say, like out at Steinmeier and Dozier, if there's a new something that comes in there and there's power poles are in the way of a new sidewalk we want the developer to install, then the developer goes to Black Hills and says, I need to move these poles. Well, they charge the developer a lot of money, but it's really the city's project. The developer's just our contractor doing the work. And Black Hills has tried to argue in the past, well, that's not a city project, that's the developer project.
So
We-
we're
we think it's
firming up
public.
that language
Yeah.
to make sure that's included as a public project, that they would have to pay the relocation of their facilities, as opposed to the developer paying it.
Right.
15.
Number 15, this one's becoming more and more common with pretty much everybody, is we're asking to use, we talked about the pole sharing, we're asking to use their facilities like they would let anybody else use their facilities, but not charge us. So an example is when we negotiated the license agreement with United Fiber, and they put in the fiber loop around town, they put in some dark fiber for us, for the city to use for public benefit. Majority of that's hanging on Black Hills poles. So again, if we for some reason had a fiber project where we needed to run out communications to the PD or the water treatment plant or something like that, we'd be able to use their poles and without being charged. So long as the facility's adequate for it. I mean, if their facility had to be upgraded, of course, had to get a taller pole or a stronger pole, then we would have to pay for that. But if it's existing facility and we can use it without, other than just basically a rental fee, then we should not have to pay the rental fee, is the argument there.
Because we're basically paying a rental fee for our own space.
Yeah.
Public right of way.
Right.
Yeah. Right?
We've done that before.
Yeah. And I think the next two are yours, Catherine.
Oh, okay. So the current franchise has a transfer fee if it's sold to another party. I have in the memo there what it currently is right now. I just need some direction if you like those numbers or you want us to come back with a different number. I don't know how those numbers were calculated.
How old are they? How old are they?
The 1992.
I think probably the math has
Probably
changed.
on the low side.
Yeah.
I'm thinking so.
At least apply an inflation factor for the time difference. 25 years.
Yeah.
So,
I'm
It-
assuming you want to keep it. The
yeah,
transfer.
I'm gonna guess we want to keep it, and I would say at a minimum, we should upgrade them by the cost of living index from whatever you said, 92 to current, and then I'd probably add 5%, just because that only gets us to today. It doesn't get us anywhere close to 25 years from now.
Right, so you want to keep that inflation as we go forward.
That's-
You could index. the
You
Index-
can
Yeah.
index
Yeah.
it, we could do
Index
that.
it as it moves forward.
Yeah.
Yeah, so.
Yeah.
you-
And then, this is kind of what, the city has a right to purchase, this is in the current franchise, this is totally common language, and then also the right to condemn if you want to become a public electrical utility.
You said it's in there now?
Yeah. Both are in there now.
Put that last sentence in bold.
All right. I will do that.
Okay, any more comments on that? Good.
Catherine, when do you think this will come back to them? For just more review?
Probably October, maybe even November, kind of based on your budget schedule. I don't doubt you want to, well, maybe you want to take them both on at the same time. It's going to be a pretty lengthy discussion probably when that ordinance comes back for, and it'll be in a committee meeting first, and maybe even in an executive session, so we can get some negotiation information from council on things they might be willing to give up, what, you know, what their priorities are.
I'll just say a future committee meeting.
Yep.
So if that's such the current franchise is only 3 pages, is it something we want to see, or is it not worth looking at?
It was pretty much an insult.
If you'd like to see it, actually, it's 2 ordinances. It splits the franchise fee from the regulations, which I have never seen and is not acceptable. So you're welcome to see both of those. I mean, so it's totally up to you.
It's pretty much an insult considering what we currently have with them.
What?
It's an insult to us based on what we currently have with them in an agreement. I mean, they basically just say we're going to be in your right-of-way
Oh,
things.
the current,
Yeah, our current franchise agreement, a lot of the things we discussed today are in our current franchise agreement. They removed.
so what could we see the one they sent us?
You
Yeah.
can see,
Is that what you
Sure.
said?
oh, you can see the old one, you can see the one they sent us, you
Yeah.
can
Okay.
see it all if you'd like.
Okay.
Yeah.
Okay.
Yeah, see what a gutted franchise agreement looks like.
A gutted franchise, yes.
And the copy you gave me is the old one?
Yes.
Okay.
All right, we're gonna move on to the last item, updates. Dina, you've been sitting there forever and haven't said a word. I'm guessing you're here for a reason? No?
Observing and potentially commenting on the signage piece.
Got it, okay. Anybody else?
The only update, I guess, we have an open house tomorrow from 6 to 8, and the staff is removing any note as to the, it was put on there by the consultant as for, relative to the potential acquisition or interest on the part of the city in that cell pond. We do not have an interest in that. I think the consultant just put it on as part of a planning process, but it clearly has created a ripple effect. We need to remove that.
How about Sonny's?
And
Sonny's?
I mean, I've had some conversation, I haven't had a chance to follow up today. I don't know if you guys have seen the Linda Carlson.
Yes.
Do you guys all get a chance to read it? The Linda Carlson letter to the editor, or speaking out or whatever she's calling it.
Yeah.
It's, I don't know if, I mean, I think just having the property highlighted in this river management plan is offensive. It's not just the language, it's the fact that it's included in the drawings.
Yeah.
It's like.
Yeah, and I can follow up on that. So I had probably about a 45-minute conversation with Ms. Carlson last week and let her know that the information that was in the alternatives phase, which was the graphics that were available about 6 weeks ago, has changed, had changed as of last week already, and that area was taken off and showing that acquisition language. So had that conversation with her last week.
Okay.
How about Sonny Smollers? Because he expressed concern to me about his property being in play.
I have not had an individual conversation with him.
Okay.
Yeah. What about the 4 mile stretch? Those people were fairly vocal.
Well, the direction is to reach out to property owners that may have lines drawn on their property in the unincorporated areas. And so that will have to occur after the meetings tomorrow.
Okay.
Okay. 6 to 8?
Yes.
All right. I'm looking for.
Great.